Welcome to today's course. We're diving into a crucial topic for Ontario landlords: what to do when a tenant stops paying rent. My name is Witing Bolu. I co-founded Openroom.ca, where we aggregate tenancy court orders across Canada and we put them to public use. We built a registry for court orders to help you search through residential tenancy dispute outcomes. My team also holds people accountable by impacting their credit histories depending on whether they pay rent or not. As of May 2025, unpaid rent in Ontario, just based on the 40,000 Landlord and Tenant Board tribunal orders that my company at Openroom has, it's now well over $287 million over the last 4 years. To break this down, I've invited Jordan Nieuwhof to join us. Jordan is a former licensed paralegal in Ontario who has served thousands of clients throughout his career, focusing specifically on landlord and tenant matters. He's now taking all of his knowledge and educating the community to ensure we make more informed decisions. In this session, Jordan walks us through the key steps of navigating unpaid rent situations, from understanding the role of the LTB to using essential forms like the N4, properly serving notices, avoiding common mistakes, completing the L1, L9 update forms, and preparing for the LTB hearing. If you're a landlord in Ontario, this is a must-watch to protect your rights and ensure you're following the correct legal processes. We'll dive in after a short message from our sponsor. As a landlord, making your properties stand out to renters is more important than ever. That's why Rentals.ca offers verified listings, a free service that confirms your identity through Persona, a trusted third-party verification provider. Verified landlords get a badge on their listings, instant posting, and up to 3 times more leads than non-verified listings. With thousands of renters searching daily, getting verified makes your property stand out as a trusted listing that gives renters peace of mind. Get verified and list for free today on Rentals.ca.
A few years ago, a heck of a case where you're actually going through the enforcement process and collecting against those tenants now. But I guess it's a great question. One of the reasons why I'm out of the LTB and more into coaching is there are, as you said, thousands and thousands of these types of cases every single day. And there's only so many you can handle at the board. There's only so many appearances I can do in one given day. But thousands more landlords need affordable help, like what Openroom provides. Through education, through the book, through training like this, we can empower more landlords to rid of their bad tenants and prevent bad tenants from coming in. And that's the key and that's the goal here. So it's unfortunate every single time a landlord does come across a bad tenant that gets into their rental unit, that bypasses the screenings, or landlords, because screening is a new and emerging technology, wasn't there before. And not everyone today knows about the screening, like accessing credit reports, like accessing the ability to do these wonderful searches through Openroom. And that's how we're still getting these bad repeat tenants over and over again. I don't know how many times in practice I would get a landlord referral from a landlord who reached out after they were frustrated to a reference, and that landlord's got the same tenant I just evicted only a few months ago. It happened a lot. It's happening less now because court actions are being published to places like Openroom. But nonetheless, tenants can still bypass screening. And we need to get them evicted. And the more education, the more a landlord knows, the faster, more efficient it is to evict. Like starting with the N4 right away. We're going to touch upon that. I'm going to get into our presentation now, and hopefully we can stop some landlords or help some landlords get that eviction. And if the tenant's already out, congratulations. Hopefully we can help you collect some money. But let's start with the beginning process here, that N4.
And
I
as
don't know if
as Jordan is going through this, if folks have questions, pop it into the chat, and where appropriate, we'll pause Jordan to ask the questions.
So I'm just going to go ahead and share this screen, hopefully, if we're working here.
Yeah, it's coming up.
Excellent. Okay. Perfect. We're going to be doing number one part of chapter of my book, actually, and so relevant today, is the emotional realities that you're going to face when a tenant stops paying the rent right from the beginning. Landlords often get themselves into situations because they act on emotion, and those emotions are running super high. But sending out a text message that if you don't move out tomorrow, I'm going to do blank to you, and that gets in front of the board, doesn't look very good to the landlord themselves. And I know that those emotions are high, they run high. You need to stop and you need to plan out your action if you're going to succeed this. And unfortunately, it's not a short route to get to an eviction. It's better than it was the 8 to 10 months, but even get to a hearing today, we're still looking at 3 months. That's 3 months of emotions that are going to be running high, 3 months of non-payment of rent, plus all the time it took to act. But you need a plan, and you need to know that once you've set that plan in motion, to be on top of it every step of the way. The tenant's in this position because of poor choices. You're a landlord, in most cases, because of smart financial decisions. The tenant, quite in many cases, the opposite. By maintaining control of the situation, you will come out victorious. But by doing rash actions, it can lead to negative consequences. I had one landlord that they were denied their eviction due to Section 83 from removing some appliances, and it's still an ongoing case several years later because of a series of errors the board made, but the one fundamental mistake the landlords made at the beginning, removing appliances, that spiraled into the board allowing the denial of the eviction that has now taken years to resolve. So there are things you can do, like issuing your N4, reporting non-payment of rent to credit bureaus, and there are things you should avoid, like removing appliances and breaching your obligations and responsibilities. So they say the board is objective once you get to that level. Some say it is, some say it's not. I can't comment from my experiences, but certainly there are board members that are tenant friendly and some board members that are landlord friendly. But the strength of your case is going to control and even sway those most tenant friendly adjudicators in hopefully making a decision in your favor. And that starts, number one, with a really good step and a really good N4. So you need to know when to issue the N4. And that is, generally speaking, the day after rent is due. Don't wait 3 months, 5 months, 8 months because you're being friendly, because the tenant says that they're going to come up with a payment plan. The biggest property managers, most successful landlords, they issue the N4 pretty much the next day, the second after rent is due, the very next day. And it's part of their process. And what they do is they include a cover letter for it. And they advise that as part of the process. But by issuing that N4 the second day, it's not that you're being mean. You're following the law. You're following your obligations. And you're that much quicker to filing with the board if the tenant doesn't make those payments. So if rent is due on the first, and it's not there on the first, and it's the second, you reached out to the tenant, say, hey, where's the rent? And there's no response, issue the N4. That 14 days starts on the monthly tenancy when the tenant receives those documents there. So the faster we do it, the more likely we can get, or the quicker we can get to the next stage. So that's what I call, as you can see here in point 2, the grace periods. They already have that 14 days before you can take any action. So why give them a week? Why give them 2 weeks? Some cases months. No, they've got a grace period. It's 14 days. File it the next day on the second. Issue that N4. Then you have to serve the N4. And oh, so many landlords unfortunately don't understand the rules of service here. Is taping it to the door is not acceptable service, and when you mail it, even by express post, service isn't effective until 5 days after. Just like courier. Courier isn't effective until the day after it was sent. You need to know the service rules. My favorite method of service is leave it in the mailbox with a photo. It's deemed served the day that you left it in the mailbox with a photograph. If there is no mailbox there, personal service, so handing it to the tenant or adult member with a witness, is the next best option. And then if those don't work, you can look into courier or mail. Just keep an eye on the service dates. Then I always had landlords scream, Jordan, what about email? What about email? If you have proper consent, you can email that N4. But I've had board members, in other cases I've watched, don't accept it. Then you have to go for a review. Unless that consent is so unequivocal that it is exceptionally clear that they have consented to email specifically on the board form or in the Ontario standard lease with the tenant's email, then you're leaving it up to the board to make a decision whether or not to proceed. And if a board member makes an error and denies it even though they shouldn't, well, you can review it, but review costs specials precious time. You're better off serving the documents in two ways, even if you have the email service. Email it and still do one of the more traditional ways of service. We want to make sure that there's no excuse for the board to deny your hearing day. And then what are the timelines for tenant payments? Well, after they receive the N4, generally speaking, again, they have that 14 days to make those payments. If they don't, on day 15, you can file. So when absolutely looking at getting your N4 done, you've got your proper accounting, you filled it out, you served it. It's important to retain that original N4 and then to complete the certificate of service. Over the years, I've had a handful of landlords that says I filled out the N4, I served it on the tenant. Great, where is it? They left it with the tenant. They didn't keep a copy themselves. We want to make enough copies for you, the tenants, and the board, and make sure they're all signed. And then complete the certificates of service before we proceed to file the L1, which we'll get to later. It's important that you keep copy of the N4. It should be basic, but so many landlords have unfortunately given away that copy of the N4 and then have to go ahead and guess what they served and when they served. I've seen cases dismissed because of this. So keep a copy of the N4 and keep a really good record of when you've delivered the notice to the tenant themselves. Now we are going to move on a little bit quicker here for the L1 application. I'm just going to pull up our L1 application here. Because the L1 application is something that is seen again as relatively easy. But if you don't have the first part right, the notice and the certificate of service, although that application can be amended, and if you call into the Ontario service line or the LTB and specifically ask, hey, if there's a mistake, they'll tell you an application can be amended. But what they often don't tell you is that the notice itself cannot be amended. So it's important to have all the documents correct before you go ahead and file that L1 application. And what you should be doing is when you're going through the L1 application, especially in the online portal, it gives you these red little blurbs. If something is wrong, it highlights it for you. You need to go back to your original notice or your certificate of service and compare to filing that application. What does the red highlight mean? Sometimes it's an issue with the address. An issue with the address can leave the board dismissing your notice or dismissing your application. Now, there has been amendments to the law itself under section 212 that says if an error is not going to prejudice a party, the application and the notice can continue. But again, what you're doing is you're leaving it up to the board member to make that decision if your error is going to prejudice a party or not. In a recent hearing, since that application has been amended, the board still found that the address was a reason to dismiss the application. The loss of that unit number could potentially prejudice the tenant. Therefore, the application was dismissed. So although that section was designed to make it less likely your application will be dismissed, not all board members are going to agree on what is likely or unlikely to prejudice the other party, being the tenant. And therefore, we need to make sure everything is correct from the names of the tenants, the landlord, and of course, the residential address and unit itself. We used to have applications dismissed or notices and applications dismissed because of postal codes. Are we going to see that now since 212 amendments? I'm not sure. I don't think the board's even quite clear on whether or not the postal code will prejudice a party. What we want to make sure is that that postal code on the application matches the postal code on the Canada address verification, which will send you a link. And that's the same postal code that is on your notice itself. Oftentimes, the lease agreement can be wrong with what the postal code is. I've seen that I don't know how many times. What you're going to do is you're going to match with what the LTB has, which pulls from Canada Post, and then send a letter out with the application as well as the notice identifying what the postal code is and why you've used your current postal code. Some of these tenancies that have spanned years and years and years, the postal code is different because there's been an amalgamation of multiple municipalities, leading to almost a double postal code system. Doesn't mean one or the other is wrong, but it's better to have that explanation of address before you get to the board. And of course, when filing your application, you have to look to make sure that the termination date itself is passed, that your amounts are correct, and you've signed the notice. So completing the application, again, it's an online application process. And if you get something wrong, the online application process now alerts you to little red key things that you should pay attention to before continuing. The actual application process, primarily, other than the numbers, is a lot of basic information. And then what are you seeking? Well, in most cases, you're seeking termination. One important thing about the application itself is the tenant needs to be in possession of the unit, whether to collect rent on the L1 or L9. If your tenant has moved out and you haven't yet filed this application, do not file an L1. You need an L10. So if you are taking notes and your tenant has moved out and you're looking to collect money right now, you don't use the L1, you need the L10 application. We'll do the L10 a different day because it's complex in itself. Just understand that this application, the L1, is specific for the tenant in the rental unit at the time of filing. So again, filing the application, there's a fee. You file the application electronically, it's $186. If you go to Service Ontario, they'll actually accept your application. It's a $201 filing fee. And I had to do it once when the portal system was down. It took a lot longer going through Service Ontario to ultimately end up with a hearing. And I wouldn't suggest it. Use the portal to file your application. Don't express post or mail it in, and don't go down to Service Ontario and file it there if you have an alternative. The best way to file your application is through the portal and that e-filing system. It also corrects to make sure that there are no errors. Again, if you can't use the e-filing system, you can go down to Service Ontario or mail it in. There is risk to that though. Best system is definitely the e-filing system. So we've talked about the address requirements, the streets, but this here was specifically that that 212 section I was talking about. This is a recent amendment. We're talking about the last several months of an amendment. And this part here was the amended section. It's super exciting because what it's supposed to do is if you've made a minor error, prevent the application from being dismissed. So if you are about to go into your hearing, let's say tomorrow or next week, and you've noticed that there's a small error on your application, write this section down, 212, sub 2, and make the argument that it isn't going to prejudice the tenant. And hopefully the board agrees with you and allows this to continue. Now, this can work for potentially the amounts, the dates, the address, and just about any issue on the application. It's up to the board member to determine, though, if it's likely or unlikely to prejudice the tenant. So major errors and calculations most likely will not be considered an error that wouldn't prejudice the party. There are limitations, but you're better off making the argument and letting the board member to decide than just withdrawing the application, because there is a chance a board member will agree with you and allow that notice to go through. So write the 212 section down if you notice there is a mistake inside your notice or application, and hopefully the board member will make a decision to decide with you to allow your application to continue. Now, again, an application can be amended. So if the tenant already moved out and there's an error, you can amend the application. That's not an issue. This is if your tenant is still in the rental unit and you're looking to evict because a notice cannot be amended. But this portion here, this particular 212.2, possibly save that notice if there's a minor error on it. All right. Basics, it's important that there's a signature on the notice, but what is more important today is because a lot of property managers actually fill out your notices. As a landlord, you may have hired a property manager to complete the notice and they've signed it. That's acceptable, But what is not acceptable is the property manager to fill out the application. The property manager is not allowed to sign that application when filing. And it's important because we've had applications dismissed over this. So as the landlord yourself, you're going to be the party. You're going to want to be the party to sign the application. Or in the alternative, your legal representative as per the Law Society, as they are also allowed to sign your application on your behalf. There is an appeal court here in Ontario that said anybody can fill out your notice. It's not giving legal advice. And that is why a property manager is allowed to sign your notice, fill out your notice, and serve your notice, but not allowed to fill out your application and sign your application. That was considered as giving legal advice, the actual application portion itself. So if you are doing this yourself and you do have your property manager and they say, oh, I can do the application for you, stop. No, you need to be the one to sign that application or your legal representative. It's your property manager cannot sign that application. And that I think here, other than all this other information, is key.
Jordan, can you pause there for a
Yes.
second? So what I've seen recently, more and more as we get more orders in the open room system, is that it'll be landlord name and then CO of X property management company. Is that the right approach to do it?
So that's again, unfortunately, what you're doing is you're leaving it up to the board. But in that case there, what's going on Openroom is the care of at the court level for enforcement, they're used to seeing that all the time. They don't care. The care of literally means care of, CO. On the actual application, you're leaving it up to the board member. I did CO myself when I had the landlord as, John Smith, care of Blank Smith Property Management or whatever it may be. Never had an issue on the notice as well as the application. Never had a board member and adjudicator bring it up. Again, I was retained as the legal representative, so it really doesn't matter at that point. But what should be important is the landlord's name should at least be on that application. And if not, and if there is a landlord that their name isn't on the application right now and it's about to go before the board, amend it and get your name on it. Make sure you are a landlord on the application. But Lanning, I think what is more important that you bring up, even for enforcement, is if the landlord's name wasn't on the application at all. Because once you get to the garnishment stage, that landlord has no rights at the court level to register that to the Ontario courts to get that garnishment. They're not a party, but their name won't be listed as a party on the actual order itself. So the landlord who now has that order can't go to Superior Court and register a garnishment or some sort of enforcement. So I would rather see landlord's name care of property management than just the property management's name. You bring up an important point there. And that point is the landlord's name needs to be on the order because you can't get to Superior Court without the landlord's name on the order. Property management company would have the right to collect the debt, file the garnishment, but the actual landlord, the actual creditor, would not. So it is important, even if it's landlord's name care of, it's important that the landlord's name is there, especially on that order, because that order is the basis to go to enforcement, to Superior Court, small claims court, to enforce that debt. So care of at the court level, perfectly fine. Tribunal level, I've never seen an issue with it, but no landlord name, not good. That's when you definitely need a correction. Sad part is, it's difficult, if not nearly impossible, to actually amend that order for the party's name once you've got to that stage of an order. So it's not like a landlord can go back and go, wait, why my name isn't on here? I'm a party. Board, change it. Well, it's already been decided on. It's already been litigated on. You weren't named in the application. You're not named on the order. You're not a party. You don't have the right to go back to the board and say, I need an amendment to add my name once the order's been issued. That can cause some serious problems. The board can say, no, you weren't on the application itself. It's a serious prejudice. So make sure your name as a landlord is on that application.
Gotcha. And Jordan, we've got a comment in the system here from Forge that says, as the property manager, filling out the L1 with the board, accept a signed statement from the landlord that they authorize the property management firm to sign on their behalf. Landlord in many cases are out of the area or country. So will the board accept something like that? A separate document that says landlord authorizes the property management firm to sign on their behalf.
What you're doing is, as a property manager, you're leaving it up to the board member to have the discretion at that point in time to go, okay, yes, or say no. When actually looking at the definition of a landlord at the LTB, it's not just the owner of the property, but it's also who has care and control to permit occupancy. And that is part of the interpretations or the definitions under the Residential Tenancies Act 2006. So it's actually very possible that that property manager, whether it be the property manager that left the comment or any other property manager out there, to actually be found as a landlord, not just a property manager, if they permit occupancy. And then they can go ahead and actually bring the application to the board and go forward as a landlord. But you're leaving it up to the board member in their interpretation of whether or not the property manager actually meets the definition of landlord. And if they don't, then they're a witness, they have no standing, and the property owner is at risk of restarting the application. So when it comes down to them giving authorization in writing, you're taking a significant risk in going through that application without having the property owner's name and signature on it. But to actually fix that situation there, as the property manager itself, the landlord able to go on to Ontario tribunals with their email and actually sign that application digitally, no matter where they are across the country or internationally or whatever they may be. They can log on, they can go through the TOPS portal, and they can digitally sign. Checkbox sign, file. There's nothing technically wrong with, in fact, setting up an account and sharing the password so that the property manager and the landlord has access there, if the landlord themselves are unable to sign it. Again, further, once you're added as a party to the application, you'll be sent a link to the TOPS to actually go ahead and sign that application. I would say if you're in an absolute pinch and you can't get the property owner to sign the application and the property manager does it, an application can be amended. There's technically nothing in the rules that says an amended application with the landlord's signature later wouldn't be considered valid, especially under the new rule 212. Is there any chance it would prejudice the other party? No, there wouldn't be a chance that, or there shouldn't be anyways. We can't say wouldn't be, we're not the adjudicator, but there shouldn't be a chance it would prejudice the other party. And 212, in the spirit of 212, means that that should move forward. But from a risk element, I wouldn't recommend doing it. From a practical element in a pinch, that application should be able to move forward. I wouldn't make it your normal practice though.
Awesome. Jordan, I've got one more before you continue. It's from C. Bonsi in the chat. On
Yes.
the N4 specifically, on the N4, how do you apply rent when they do pay? So, for example, C. Bonsi's tenants, my tenant is still paying, but has been in arrears for over a year. Is everything they pay applied to the last outstanding balance or the current balance?
Well, that is an interesting question. And more adjudicators than not go that the amount owed goes to the last period, and that is fairly standard. So the amounts that have been paid get applied to the oldest accounts first. So January 1st, 2000, let's say this month they didn't pay, or sorry, January 1st, 2025, they didn't pay all the way. Let's say we're in March. It's only 2 months here. March 1st comes around, they make a payment. That a payment would be applied to January 1st, 2025, the oldest accounts first. And what you should actually do is you should actually show your rent ledger. I wish I could be able to pull one up quickly, but what you should show your rent ledger is the payment periods, and then the date actually of paid, and then the date applied. And it makes it really nice for the adjudicator where you can show them that says, yes, the tenant made a payment on this date, it was applied to this balance, here's the running total. So despite the fact that they made a payment today, it does apply to the oldest accounts first. And that's fairly standard among all the adjudicators. What gets more interesting though is if you don't have this N4 and you get that N8 persistent late payment application, because divisional court or appeal court made the differentiation between non-payment of rent and persistent late payment of rent. And that if the tenant hasn't made any payments whatsoever, it can't succeed on an N8, but it can succeed on an N4. Then I would have again the rent ledger clearly labeling it out, and I'd make the argument that they made a payment. It's persistently late though. So your rent ledger should have the date the payment was made, the date the payment was made in one column, period it was applied to. And it makes it clean for the accounting because the board member may spend some time going over it with you. Wedding, I think what we're going to do is we're going to add a template here to this package when we send it out. I do have it. We just don't have time to show it today, but it will be in Excel that the landlord can fill out and or create their own, showing very clearly the date that the rent was made and the date it was applied to. And the board member will be able to see that very clearly. And then the tenant goes, well, I paid my rent in April. Oh, you may have made a payment in April, but it was applied to last year because you're 13 months in arrears. So when you have that paid and date or that date applied on, the tenant can't say, oh, the accounting is all ruined and they don't know because I made a payment on this day. You can then go, yes, you did make a payment on this day, but it was applied retroactively back to blank. For that question to be very specific and very clear, rent payments are accounted for the earliest date, the oldest that first. And that's your general accounting practices as well.
Awesome. Thank you very much. Ready for our
Any
next
other?
one.
All
Good for
right,
now.
excellent. We are good for now. Excellent. So the next thing we're going to go here, I'm going to touch upon it briefly, is once we have actually went ahead and we have filed this application, and I used to get pushback this from lots of landlords, it's a good idea to send them a package that also says, hey, we need to make a payment arrangement or a payment plan. And landlords used to scream at me all the time, why are we giving them a payment plan? They haven't paid in months. Section 83(6) of the Residential Tenancies Act says you, the landlord, must make an attempt or an offer to the tenant for a payment plan. And board members have said, I don't want to just see one attempt. They like to see several attempts to satisfy Section 83(6). What's the best way to start? When you got your whole package ready to go and you serve it. And then I like to take, after I file the application to the board, I like to make another letter that says, hey, I'm serious. Number one, I filed this and I'm going to start reporting your debt to the credit bureaus because that's my right. It's going to affect your credit. However, we can avoid all of this if you commit to a payment plan. Then I like to take the blank LTB payment plan, fill out the top of it, landlord name, tenant name, the debt owed, and with a letter that says, fill this out and return it to me, and we can discuss getting you back on track. I take that and I provide it as evidence to the board that on this day I served the tenant with payment plan request. And then I will do that when I get the notice of hearing, if they've ignored it. And then I will do that again just before the hearing, just a few days before the hearing. So therefore, I've done it when I issued my N4. I did it when I issued my application. I did it again when I got the notice of hearing. I also served the notice of hearing on the tenant with my payment plan, and I sent it out with my evidence just days before the hearing itself. So I've got 4 opportunities that the tenant could have came back to me with a payment plan and they neglected and or failed to do so. Therefore, I have no reason to believe that should the board impose a payment plan today at this hearing, the tenant's going to follow it. They've had countless opportunities to propose a payment plan and they have not. That is an extremely powerful line in your closing arguments for the board to consider, going, wait a minute, the landlord's right. they were provided multiple opportunities to make a payment plan and ignored them all. Yet on the day of the hearing, they have one. Board has to take into consideration what's fair. They also have to take into consideration the evidence that you tried multiple times and that led nowhere. So despite screaming, we're going to do multiple payment plans before we get to the hearing itself. Now, once you're at the hearing, you're going to make your arguments. The tenant's going to make their arguments, and the board's going to generally issue an order. And that order contains a few different things. Number one, the worst of all, they could dismiss your application in its entirety because there's an error for whatever other reason. In an N4 hearing, if everything's right and the arrears is actually owed, unlikely that they're going to dismiss the application in its entirety. You do have to be prepared and be mindful that the board can order an application to be dismissed for various reasons, whether there's a technical error, whether the account numbers aren't right, whether there's a Section 82 maintenance issue that offsets the rent, or worse, a Section 83 that there's a serious issue in the residential unit that warrants the denial of eviction. So they can dismiss the application. But when the landlord has done all their due diligence in following the law, the most common two orders that you're going to get is what's called a Section 78 pay on time order, or you can file for an eviction without a hearing, or in the alternative one, a standard or delayed standard order, which means a tenant has to pay up a certain balance by a certain date, or they're going to be evicted, and that balance has to be paid in full. Most landlords want the standard order. You hear about that all the time. Standard order, standard order. That's an 11-day eviction. Many other landlords get the delayed standard order, which means that, it's not an 11-day eviction. It might be a 30-day eviction. And the other extremely common order that I see more and more is, in fact, the Section 78. And that Section 78 is where the tenant is given an opportunity to make payments and pay the lawful rent on time, or else they may face an eviction. More times than not, in my experience, the tenant never actually did comply fully with the payment plan, and we ended up evicting them. Generally, the first few months they've complied with, and then after that they breached and we're at an L4, and then the tenant gets evicted. Sometimes they've come up with the money to save it, but in many cases they get evicted on that second or third round at the board. But I guess the exciting part here is now that we've got the order, and we're going to assume that it's an eviction order here, we get to go to the sheriff. Lots of clients are like, what's the sheriff? Is the sheriff the police, the police, the police? No, the sheriff's not the police. Actually, where you're going to find your sheriff, you're going to, in most cases, find your sheriff and the actual small claims court in your area. So a lot of landlords are on Google going, where's my sheriff? They're not finding the information because the sheriff's actually at your small claims court. So instead of typing in where's my sheriff, you could be typing in where's my small claims court. And we're pretty responsive. You can give them a call during their operating hours to make sure that that is the jurisdiction of the sheriff. Because in some cities, it doesn't quite make sense. If you're living on one of those border areas that the court has jurisdiction over, you may actually be traveling further than a closer courthouse. It's just the way that the government has divided the jurisdictions. So your sheriff, where you're going to be going to file for that good old eviction, is not at the police department, but actually found in almost all cases in your small claims court. So when you got your order and you're ready to go to the sheriff, Google your city's name, small claims court, and try there first. That's where your sheriff's going to be. And what do you need to go down for the sheriff? Well, you need the court order and you need some money. And then they're going to give you a form to fill out. Now, you can fill this form out online, or you can actually go to the courthouse and they'll give you the form. It's a basic form. It asks some basic questions, the unit number, is there any criminal convictions, guns and dogs and stuff, basically for the sheriff's safety. But you just fill out this form and give them some money, and the sheriff will take over the rest. They'll contact you. It's not a complicated process. I don't know how many times I was asked about, Jordan, how do you file with the sheriff? The sheriff's a simple form. You just go down to the courthouse. They'll give you the form. They'll help you fill out that form. And then you pay them the money, oftentimes $340 or more. And then the sheriff will contact you on the day that they are coming to evict the tenant. One thing important though, the day that the sheriff's coming is you need to make sure that you have your locksmith there or someone with the ability to change the lock. The sheriff, in almost all cases, will not exercise an eviction without the locksmith or you with a set of locks there. So that is important. Out of everything else, make sure that when the sheriff says, I'm coming between 8 and noon or whatever time, you have your person there with the locksmith ready to change that lock. That is important. And the sheriff's going to do the rest. They're going to post a notice to they're going to get the tenant out. They're going to post a notice to the door. And then you have to retain the property for 72 hours and allow the tenant access for property for 72 hours. After that, the mess becomes yours. The property becomes yours. And you get to deal with the remaining arrears and what to do with the property itself. We're not going to get into what to do with the property because that could be a whole case on its own. Just make sure that you know your rights, that you can't just throw out the stuff, and the sheriff's going to give you a bit of basic information about what to do with the property. 72 hours is key. You have to allow the tenant access for 72 hours. Does that mean that the tenant has access willy-nilly, freely, and then here's the keys back and you can go in? No. I recommend that you, a security guard or somebody, a friend, I don't care who, is at the property and they have specifics, 8 a.m. till 8 p.m. They have access. They can't spend the night there. You have rights. The property is yours. Once the sheriff posts that notice to the door with a big fat red seal on it, the property is yours again. It's not the tenant's rights anymore. It's your rights. You're allowing them access to get the property. If you're completely uncomfortable with allowing access to get the property, you can technically move it to a storage unit close to the rental unit and give some instructions for the tenant to go and access their property. I've had that done. I've had other landlords move all the property to the garage, and say you can get it all from there. That's technically allowed. I've had landlords who have purchased or rented a storage unit, the big metal ones, have moved all the property into there, gave them access for 72 hours after that have gone. That's legal as well. You don't have to allow them access into the house. You have to allow them access to their property. Keep that in mind. You are now in possession of the house. It is now your house. It's always been your house. The board has something other to say than that, but it truly is under law. The possession of the house is yours again. It's just about getting the property to the tenant, and there's various ways of doing that.
Jordan, we've got some really good questions in the chat here. So
Of course.
from Forge again, we've got a stay of an eviction order is given by LTB without consultation to the opposing party, which is the landlord. Tenant lies to the board, providing a sob story or a lie, but the board makes no attempt to corroborate of the actual facts regarding the request for a stay. Now the landlord has to wait another 3 months for a hearing to determine if the eviction was even appropriate. Makes no sense at all. Can you comment a little on that?
That is absolute BS. And I've seen it happen, unfortunately. I've seen it all the way where after the sheriff has came and evicted the tenant, the board made an order restoring the tenancy and allowing the tenant back in, and then giving direction to the sheriff if the landlord did not go ahead and provide the keys to forcibly allow the tenant back in, and that they could then go ahead and change the lock. They had an order after the sheriff came to regain possession of the rental unit. The board has the authority. And what you're explaining in the question, I've seen many, many times. In fact, more times than not, where the sheriff's about to come out and they get a stay issued by the board that says they can't enforce it. Unfortunately, a very common and frustrating situation that often results in the landlord just feeling like they're going to give up. It's unfortunate. It happens. They claim it's part of the process. And my thoughts on it is that law needs to be repealed and amended completely. It's absolutely ridiculous after a case has been decided that the tenant can make a sob story when the sheriff goes out or can't go out any longer. The sheriff is blocked, and then there's another hearing months down the road to determine if the tenant's sob story is real. That's not right. It really, truly isn't. I could go into various amendments, but when a tenant files a stay, the landlord should have the right to respond in writing. I think it's ridiculous that the board can make an order without hearing the other side, even if it's in writing. And that is something we need to be advocating for and change. You bring up a real great point, and we need a committee on this to lobby the government to make a change where even if it's a motion in writing, the landlord has an opportunity to respond. You get that in small claims court. In small claims court, when there's a motion, it has to be served on you, and the other side gets an opportunity to respond. Why is that not the same at the board? You bring up a point, and we need to advocate for change. Open Room needs to be on it, Solo needs to be on it, and you're right. We need a change to that.
Maybe
Yes,
this is
he's
your new,
literally-
maybe Jordan, this is your new career, right? If you're not practicing paralegal, you lead the efforts. All right, all right. Let's keep going. Okay, so Jenny, I'd like you, I'm going to unmute you because you've got a pretty big question with some background story here. So feel free to go ahead.
Hi, everyone. Hi, Jordan. Yeah, so the context here is that I inherited tenants in a multiplex 5 or 6 years ago. I don't have their original leases. The dates were not confirmed in the direction to tenants, which I got from the lawyer. So I've got a tenant who I've served an N4 to a bunch of times, but he always seems to pay it right before, on that day 15. So I just want to be prepared because I've proactively filled out the L1 a few times. So in section 4, it has a section about for the amount of the rent currently on deposit and the date the rent deposit was collected. So I purchased this home. I have no idea what those original dates were. So for the date the rent deposit was collected, would I put the date of purchase because that's when I received the discount on closing? Or do you leave it blank?
It's interesting because this actually I've dealt with this in quite a few different cases. Luckily for you, has no impact on the N4 itself. So there's no issue that, oh my goodness, if this is wrong, my case is going to be dismissed. No, no, no. You're safe there. What the board is going to do in this case, and you're going to bring it up, it actually doesn't matter what date you put in where that last month's rent deposit was collected spot. You're going to see that again in your L1, L9 update form. But I put the date oftentimes, if we didn't know and we weren't completely sure, I put the date that the house closed on. Exactly what you're going to do because that's when you receive the deposit back. The tenant
Okay.
may make, yeah.
And just the follow-up to that is about the last rent period for which interest was paid on the deposit. I've never paid them interest. I've just, I've been applying whatever the last month's rent was. They get that month in full whenever they move out. So for that date, it has like a to and from day. Would you just put the year of the last time you increased the rent? I've read online that if you increase the rent annually, you don't necessarily have to pay interest every year on the rent deposit. You just have to give them that last month's for free. If that makes sense.
Well, it does kind of make sense actually, but what you're referring to is both the previous question and this current question, and both those lines are related to how the board is going to calculate that last month's rent deposit. That's why they want to know when it was collected and when's the last time you paid interest on it, because then they're going to go ahead and make the calculation in their automatic calculator that spits out a number that goes in the order to offset the arrears owed, or if there is no arrears, to the amount that the landlord is going to have to pay depending on the application. What you're referring to is topping up the last month's rent. So every year when the landlord increases the rent, they have the right to apply a top up directly to the last month's rent. So you're exactly right. At the end, the tenant doesn't owe you any more money. And that interest that's owed went to the LMR and it's been added, and then you don't expect any money when the last month's of the tenancy comes due. It's like a wash. You have to, though, and what the legislation doesn't tell you, but some board members expect it, is to provide some sort of evidence and or proof that you have done that. Otherwise, the board member is going to say, you know what, I'm going to put it in my order that it's owed anyways. You haven't provided me any proof that you've actually applied these top ups. And then they may turn to the tenant and ask the tenant what they want to do for the last month's rent, and or if they've been provided any top ups that they're aware of. And the tenant in most cases go, I don't know, I never received a letter. The board will put it in the order anyways. As for what you're asking for on what dates to put in there, That's the last date that the interest was paid in accordance your knowledge. Are you applying a top up? Then if I were you, I would write I am applying a top up for the rent on this day to account for blank, and then I would put it in in the date that you last paid and for what periods. And that applies to a top up. Then you're going to make the oral suggestion at the board that you top up. No interest is due upon termination of the tenancy. But what's
Okay,
interesting is, I believe, if I'm not mistaken, you said you don't know when the tenancy commenced?
yeah, the tenant had been there for a long time before I bought it.
The board's going to want to know that. The board is going to want to know when the tenancy started. And that's most important. You need to figure this out now before you get in front of the board. Because if you don't know and the tenant says, I moved in January 1st, 2000, I've never paid interest, you're going to be paying interest from January 1st, 2000 all the way forward.
Mhm.
Your directions that your lawyer completed, they should know whether or not the tenant was paid out that interest as a result of the sale. Some lawyers will send the tenant a check saying, as of this day, you are paid all the interest. Other lawyers will then send what's supposed to be to you from the old landlord to you to top up on that interest. And it should be in your statement of adjustments on your reforms there, on your contract. You should see the adjustments. And in that statement of adjustments, it should show the interest owed to the tenant, whether it was paid out or whether it was the balance was transferred to you.
Okay.
Thank you so much for tuning in today. I hope you've learned at least one new concept. Please consider subscribing or giving us a thumbs up so we keep sharing high-quality educational courses on Openroom University. Check out our other videos to make sure you stay informed. If you've got feedback or just general ideas for my team at Openroom.ca, please send it to us at hello@openroom.ca. Cheers to a transparent and connected rental ecosystem.